Hey, everybody. This is Kevin Sutton, chair of the Education Practice Group here at Miller Johnson, and excited to share another 5-minute message with you on a topic that has been on everybody's mind in recent weeks and months, and that is the controversy over books that we might have in the library, books that might be in our media center, and parental or community group objections about those books. No shortage of opinions on this. And obviously, we've seen a number of examples in the news recently of protests at board meetings and community groups having significant concerns about many of the books that are in our libraries and media centers. And so we wanted to do this 5-minute message to talk a little bit about the basics of this, the nuts and bolts of this, and what do we need to know about this idea of banning books in school. The truth is there's not a lot of law on this topic. As a general rule, curriculum, as long as it's consistent with legal requirements, is within the discretion of the school district. That is largely set at board level and then guided by central administration, consistent with the Michigan Revised School Code. Curricular materials can be added to, modified, or even removed from the curriculum without really any concerns or any problem. Library and media center materials, though, are a little bit different, and there's a few different restrictions on that. We sort of think about it in two ways: putting materials into the library and taking materials out of the library. When it comes to putting materials into the library or the media center, that is still essentially a discretionary call of central administration. But removal, on the other hand, once materials are in the library, so taking those materials out, removal of material that has already been shelved is a little bit of a different matter from a legal perspective. If the board removes a book that it doesn't like or that certain community members don't like, and someone objects to that removal, a parent or a student, there may be liability for the school district or the board if they simply ignore that person who has objected to the removal. This goes back to a 1982 U.S. Supreme Court case called Island Trees Union Free School District versus Pico. And there we had a school board that removed several books from the school library, in part because the board thought the books were anti-American, anti-Christian, and anti-Semitic. They also described the books as being, quote, just plain filthy. The court held that the removal on this basis was a violation of the students' First Amendment rights, because the students have a right to be free from the inappropriate suppression of ideas. So in that case, they said they shouldn't have removed the books from the school library. But in issuing this decision in 1982, the U.S. Supreme Court did explain that books can be removed for a whole bunch of reasons, namely pervasive vulgarity, lack of educational value, things along those lines. But simply having an incorrect or unpopular opinion in a book on politics, nationalism, religion, or something similar is not grounds to remove a book. So I guess the short answer is there's a little bit of wiggle room in both directions, and books can be removed, but not just by fiat, and not just because somebody thinks that it is not a popular idea, or somebody thinks that it's got a political view that is not the political view that they share, because the U.S. Supreme Court has said that students should not have ideas suppressed. They should have access to those ideas. But again, if something is pervasively vulgar, if it lacks any educational value whatsoever, those books can be removed more simply. So how do we do this? How do we navigate that, and particularly in the current environment? And the key answer is process. What we have to have is process. And if we have process, largely we're going to be okay in terms of how we navigate this. But as long as we have something articulated either in board policy or perhaps in our administrative guidelines or regulations about how we're going to take these parent concerns or community concerns about library or media center materials and what process we're going to go through to vet those concerns. If we have an established process and we follow that process, whatever the outcome is going to be legally justified. It's districts that don't have a process that are finding themselves maybe in a little bit more hot water. To be clear, the process doesn't have to come out with a result that everybody will agree with or everybody will necessarily like. But having a process and following that process is the key to navigating this present political hurricane that's going on with respect to this idea of books and removing books from our libraries and media centers. No shortage of opinions, no shortage of complications or complexity to this situation, but that's how we're recommending to our clients they navigate it. As always, if you have questions, please feel free to reach out. We're happy to support in any way we can. Thanks so much. Take care.